from the soothing songs that lift your spirit to law. Actually, I don't mean it that way.
You better not.
Well, let's welcome our lawyer on the line, Verla de Pisa. Good morning. How are you?
Good morning. I'm quite fine. And good morning, Barbados.
There's a broad smile on your face. Was there another case where the defense attorneys ruled?
No, hopefully that will be later on today.
Oh, well, look out.
Charging up.
I'm telling you. But
No, it's not that kind of matter.
It's not that kind of matter.
No.
She looks so excited. Though. It's like, oh,
That's
can't
the
wait.
passion. When you lose the passion, get out.
Yeah.
Oh, yeah.
So, are we going to talk about family law again? We're getting back into those murky waters.
The children this time.
The children.
Okay.
What's there to say about the children? Are they just provided for? Is that, are they well taken care of?
Doesn't good sense just prevail in the sake of the children?
Yeah, it doesn't.
Well, a lot of times when there's dispute within the family, good sense is the first thing to go through the window.
My goodness.
And that is
We're on
when
a
the courts
high
have
with
to
the music,
intervene.
and Brilla brings us right back down to reality.
Good sense, where is it?
Oh boy, off you go then, Brilla.
So what are some of the key issues that usually pop up in the
The most prevalent one, obviously, is the maintenance of the child. But there are other issues as well, starting from the custody of the child, who is to look after the child, which for us is a different thing from custody. One is care and control and one is custody. And the difference is custody is the person with whom the child, the custody is who has responsibility legally for the child, and care and control is the person with whom the child lives and who is responsible for the day-to-day care.
It's not one and the same thing.
They're not one and the same thing.
So, but you can have one and the same person doing both, or
Absolutely.
can it be separated?
Yes, it is ordinarily separated for one of the parties in any event where the parties are not together. They may share custody, but only one has care and control, I beg your pardon. So custody ordinarily is joint unless there are issues that the court has to decide, but care and control usually rests with a particular person.
I know who that person is, but what does the law say?
Well, the law is different depending on the status of the parties making the application. If the parties are married, then they really have an equal right, and there will be some measure of investigation by the court as to what is in the best interest of the child, which is the overriding principle in all family matters involving children. Where the parties are unmarried, there is the presumption that the mother is the person with whom care and control will rest, unless the mother can be proven to be unfit. That too is, of course, a contentious issue and is usually for determination by the court.
I was just about to say, how easy is that to do, though? Or maybe I should put it the other way, how difficult is that to do? To prove, not just the mother, but a party to be unfit. What are some of the standards that has to be met, that have to be met?
Starting at the top end, obviously, is any form of abuse. But the ability to take on the day-to-day care or to make decisions in relation to the child are closely examined by the court in relation to both custody and care and control. So a person may be well-intentioned but simply unable for health reasons, for financial reasons, for circumstances to take care of a child. And so long as there's evidence of that, and this is not just hearsay evidence, in almost 100% of the cases, either the welfare department, the child care board, or the probation department is asked to provide a professional assessment having examined the situations of all the parties involved. And I must state that this doesn't only apply to parents, persons who are not parents, and in some cases, persons who are not even relatives have applied for custody, care, and control of children.
My question, Verla, is the type of so-called abuse that is harder to prove. I've always thought, and professionals will bear out the fact that it's easier to prove physical abuse because you have scars, but the behavioral implications of emotional abuse are a little bit harder. What about the cases where you will hear that the one parent is pitting the child against the other, either in obvious statements or in subliminal actions or subversive little comments? Where does the burden of proof lie?
The burden of proof always lies in the person who is making the allegation. He who asserts must prove. That is a general overriding principle in any court action. But again, because in family matters there's a tendency to be subjective, there is the intervention and the need for these professional reports before the court, before it makes any determination. The court will make what they consider interim orders, will make a certain deliberation. But outside of that, they prefer to wait on the professional assessment as to what is in the best interest of the child before going forward.
All right, we have 2 callers on the line, so let's go straight to our phone lines. First of all, Brian. Good morning, Brian.
Hi, good morning.
Good morning.
Good morning.
How are you doing?
Not good at all.
All right. I have a question. I want to ask a question with regard to a particular circumstance I am aware of concerning a friend of mine. Now, you said, and we agree, that the best interest should always be the child's care, concern, and welfare, and all that stuff. There is a certain gentleman who recently had a custody battle. He's not married, but he is a very, I would say, well-off person. He has his own home, he has his own car, he has his own job, and he's an investor, so to speak. He had a custody battle with which the magistrate awarded custody to the child and awarded him visiting rights. Now, there is no abuse, physical abuse or verbal abuse in regard to this. It's one of those grudgeful things. There's one way to get into that. But what I would like to know is, why would the judge, having done the investigation, give the child over to the mother for custody, allowing the father visiting rights, when he has more than adequate provision to care for 2 or 3 children? This is his only child, but the young lady already has 3 other children and is currently sharing a house with 2 sisters with 4 other children. So there are at least a dozen people, including her mother, living at this particular house, and she has the custody of that child. How can you explain that, and why would a judge make a ruling like that?
It's actually a lot easier to explain than it sounds, because we're right back to that first consideration where the parties are not married, of having to prove her to be an unfit mother. The fact that she lives with an extended family is actually not a negative. It will be viewed as a positive, because there will be more supervision for the child in those times when she personally cannot do it. Because you are not wealthy and living in Sandy Lane does not suggest that you're not able to provide for your child in a meaningful and reasonable manner. And because they are not married, he would have to clear the hurdle of proving her unfit before he takes custody, unless of course she relinquishes custody of the child to him. But simply because he has greater financial resources does not mean that he is the better person with whom the child ought to live.
Does a child ever have a say in a situation? I mean, I'm sure the age might have something to do with it, but children are often seen as very persuasive. So do they have, does their feeling count, or not really?
Children are very persuasive, but they're also very easily persuaded.
Right.
And the younger the child, the less likely the court is to take into consideration what the view of the child is. But children 15, 16, and for certain past 16 can give their opinion to the court as to where they want to live. It does not necessarily mean that that is a foregone conclusion, because they're also of that age where they are well honed in manipulative skills as well.